forced to be a single mother, and I forever have to explain to my kids that daddy would never, ever come home. He won't be a phone call away. I'll struggle raising my kids on a one-parent income. I'll never be able to get that help or support that I need because my husband has been taken away. My husband did not deserve to die. And I should not have to live in fear while waiting for the man who killed my husband to be tried in court. This defendant should not be treated like anyone else who is accused of taking someone's life without remorse. Considering the victim, considering the violence, the violent nature of the whole scene, I feel like he had complete disregard for my husband's life or any other body that was standing out there. Because there was 3 shots fired and only 2 entered my husband. And it could have been someone else's child or somebody else who could have been hurt that day. And I thank God that it wasn't. I can't sleep at night because I'm scared. And if he was released, I can only imagine where my mental state would be. I would be so scared because I don't know what they would do. I can't even go outside of my house now because so many people said hateful things. My husband wasn't perfect, but he didn't deserve to die. And I'm just so confused because 41 minutes of a conversation felt like he was being harassed. You could have already told him, hey, sir, we smell it on you. We're going to lock you up for this and that. And it could have been summed up from there. But instead, I feel like he was harassed and played with the whole time. So, Your Honor, I'm asking that the bond does not be granted due to my health, my mental state. I have to still raise my children. I don't have a big support group. It's just me and my children. That's all I have. My best friend has been taken. My helpmate has been taken. And never in a million years I would imagine myself being called a widow.
Ms. Miller, I want to thank you. I don't know if you can hear me, but I want to thank you for speaking to us today. And I heard you. All right. Thank you, ma'am.
Thank you.
Mr. Rucker?
Yes, thank you, Judge. In conclusion, I would just say to the court that under OCGA section 1761, 2E, amongst other things that the statute lays out for the court to consider, the accused's financial resources and other assets, the earnings and income, the financial obligations, the purpose of bail, and any other factor that the court deems appropriate. The setting of bail by a Superior Court judge, as you know, Your Honor, is discretionary. It is not mandated by law. We are here asking the court to deny bond in this matter. And some factors that the court can consider is that, one, we expect, based on Justice Melton's judicial emergency order, that we would be able to convene grand juries in a few months. And potentially this issue of bond can be revisited again. We know now from the impact statement that the Brooks family will suffer more emotional harm should the defendant be granted a bond and allowed to not be in custody. And I would say, Your Honor, that the court can also consider the potential harm to the entire community in the consideration in this matter. If the court is so inclined to set a bond in this case, one additional condition I would ask from the court is that as part of the condition of bond that we know from the experts that the phone that is in question that I have talked about during my presentation can be erased or wiped remotely. So even though I have physical custody of the phone, it can be erased or wiped remotely from another location. I would ask the court to condition bond that not occur. And I want to thank the court for giving us time to make our presentation.
Any response, Mr. Pines?
Your Honor, I do have argument for the court, but I know we're going a little long and the court has other matters. So is there anything particular you want me to address, or may I just respond?
I'm anxious for you to respond. I will say that I did not hear anything with regard to financial ability.
The financial ability to make a bond, Your Honor?
Yes.
Okay, so Mr. Rucker is correct that the City of Atlanta did fire Garrett Rolfe, so he did get fired. However, Mr. Rucker did make mention that there has been a fundraiser for Garrett Rolfe, the same way there has been a fundraiser for the Brooks family. These are just people in the public who are donating money. None of that money is in the possession of Garrett Rolfe. It's either in the possession of the people who raised the money or escrow accounts. But if the court is not inclined to grant a signature bond, then Officer Rolfe can make, or Garrett Rolfe can make a reasonable bond in this case. Just as a little bit of a comparison, I know that the district attorney's office says that they've prosecuted and are prosecuting other police officers. None of those police officers are still in jail. I believe the last police officer to be released was Officer Burns, who was given a $240,000 bond by Judge Woodson back when magistrates were giving bonds on murder cases. If the court's not inclined to give a signature bond, we would ask for a bond in the range of $50,000 to $100,000, that being a good bond, either through property, surety, or bonding company, or cash, whichever way that the court would like to do that. Obviously, we'd rather a surety bond if possible, so that he can use a commercial bonding company. Or, as you know, the Fulton County Jail has a 10% program. That's always an option for the court too. But do you want me to address some of the factors, or I guess some of the stipulations that the state would like to put on the bond, or would you like me to address some of the arguments that they made?
Mr. Pines, I'd like you to respond. That what you address is totally up to you.
Thank you, Your Honor. So let me just kind of go back from the beginning. 1761 actually doesn't talk about ties to the community. It's not a factor under the statute. It is under Ayala. But through what Mr. Thomas told this court, Garrett Rolfe has tons of ties to this community. He was born here. He was raised here. He went to school here. He was employed here. We did not tell you where he lived, although I think that one of the character letters did say that Officer Rolfe did live in the city of Atlanta at some point prior to this incident. But of course, we will disclose in confidence where he will be living, but we do not want that public for his safety. The same way that, Mrs. that the Brooks family doesn't want their information to be out there in the public. So he has tremendous ties here. Everything is here in the state of Georgia. If you like his passport, we would surrender his passport. That's not a big deal. The state in its argument is that this is not a justified shooting. It's clear as day, and therefore he has every reason to run. And so I have to rebut that because that's an argument that they made to Your Honor. So whether a grand jury decides if this is justified as they're required to do under the law when this case is presented, and just so the court knows, Paul Howard in his press conference said that this case would not be presented to a grand jury until January or February of 2021 because there are 7 other cases ahead of it, and that's in his press conference. But when this case is presented to a grand jury or a judge during an immunity hearing or even a jury, there's a justification defense and that Garrett Rolfe is entitled to. And 17420 talks about when deadly force can be used in an arrest. And it says that deadly force can be used for a suspected felon. And in our brief, Your Honor, we gave you a memo from the Atlanta Police Department that outlines at least 5 different felonies that Mr. Brooks committed that night. 1 was punching Officer Rolfe in the face. 2 was stealing Officer Brosnan's taser. 3 was pointing the taser at Officer Brosnan. 4, although I don't know that the officers knew it at the time, it's actually a felony to take a weapon from a police officer. Mr. Brooks was a convicted felon. He can't possess a weapon, even a taser. And then, of course, he fired the taser at Officer Rolfe. So it's clear that he was a suspected felon. And so the only other indication under the law that says whether our client can use deadly force is whether the suspect possesses a deadly weapon or any object, device, or instrument which, when used offensively against a person, is likely to or actually does result in serious bodily injury. And also in the brief that we filed, we attached a warrant, and that warrant was sworn out by the Fulton County District Attorney's Office in another case against other police officers where Paul Howard and his people, when I say his people, one of his investigators, so anybody who does something, as an investigator for the Fulton County District Attorney's Office is doing it for the district attorney, has sworn under oath that a taser is a deadly weapon. So that's going to be the justification. There's a whole bunch more that I'm not going to go into, but that's the simplest one. And so, the state can say that this is clearly not justified, but that's not for you to determine today. That's for a grand jury, a different judge during an immunity hearing where the standard is preponderance of the evidence for us, and then ultimately, if we get that far, a jury to determine beyond a reasonable doubt whether it was not justified. And that's kind of what Mr. Thomas was talking about when talking about the factors of this case. So the only other factor that the state contended we did not meet was there's a significant risk of intimidating witnesses or otherwise obstructing the administration of justice. Now, I don't know, I'm not really going to address who Garrett Rolfe texted that night. The only witnesses that were there were Officer Brosnan, and if this court orders that he have no contact with Officer Brosnan, then he will have no contact with Officer Brosnan. There's some police officers that came after the fact. They're clearly not witnesses, but we have no problem with him not having contact with any other police officer that was on the scene. And there are eyewitnesses. Now, my understanding, Your Honor, is that all of the eyewitnesses are represented by private counsel. I know that Sean Williams represents at least 2 eyewitnesses according to his press conference. Mr. Davis represents, I believe, 2 eyewitnesses. And there's a lawyer named Kalpin, K-A-L-P-I-N, Shaw, S-H-A-H, who represents, I believe, a couple of witnesses. So, all those witnesses are protected. Of course, our client, Mr. Rolfe, is not going to have any contact with any witness whatsoever. So we have no problem with that. The district attorneys wants us to give up a passcode for a cell phone. Yeah, that's a completely improper argument for today, but here's what I'll tell this court. A case from Florida has no application in the state of Georgia. There's many federal circuit, 11th Circuit cases and other cases that talk about this issue. Plus, no other jurisdiction in the United States except for Georgia has our rule against self-incrimination. And had Mr. Brooks actually complied with being arrested that night, Officer Rolfe would have read him the Georgia implied consent card and asked for a breath test. And according to the Supreme Court, Mr. Brooks wouldn't even be required to submit to a breath test. So, you know, if the state wants to try to go get another warrant from another judge, and we can argue whether Officer Rolfe has to give up a passcode, that's an issue for another day. I think it's completely improper to publicly talk about his right to exercise his constitutional rights. And the DA's office knows that he's exercising his constitutional rights because I wrote him a letter that said that. And so I would ask United to consider that. There's no indication that an ankle monitor is needed in this case. Your Honor, you know, this Fulton County, I don't know how many murder cases you have, and Mr. Thomas said this before, but here's what I'll say. If Garrett Rolfe isn't entitled to a bond under the statute, then nobody is. Nobody for a murder case. This isn't a drug deal where people, you know, decide to commit a felony that involves potentially weapons. It's not an armed robbery where people go out with a gun to rob a store. It's not a carjacking where you try to take someone's property. It's not a burglary where you break into somebody's house. You know, the state's case at best is that in a second, in 1 second, Garrett Rolfe made the wrong decision. That's their case at best. And that wrong decision, according to the state, came directly after Mr. Brooks turned and fired a taser at Officer Rolfe. So if he's not entitled to a bond, I don't know who is. An ankle monitor is not required. A curfew is not required. We will definitely turn over his passport to the court or to the district attorney's office, and we have no problem with Officer Rolfe, Garrett Rolfe, not possessing any weapons, which would include firearms or other weapons. You know, when you say knives, I don't know what that means. Does that mean you can't have a steak knife or a kitchen knife or something like that? And then the last condition they asked for was no contact with the Brooks family, which we have no problem with either. And I know it's been a very emotional day for the family of Mr. Brooks, and I'm mindful of that, and Mr. Thomas is mindful of that, and Garrett Rolfe is mindful of that. This, you know, police officers wear bullets to their job because their lives are in danger. And from the transcript that you have in your possession, you could see that Garrett Rolfe was completely professional with Mr. Brooks until Mr. Brooks decided to resist arrest and escalate the situation, leaving Garrett Rolfe no choice but to use deadly force, Your Honor. Okay. So I would ask for a reasonable bond with the conditions we discussed. And of course, I'll answer any questions that you have.
Okay. If everyone will just give me one moment. Okay, now one thing I'd like to bring up with both sides, and it's not necessarily a question, but these are charges. I'm so accustomed to talking about counts in an indictment, and I'm not completely clear which charge links up with which particular arrest warrant. So when I talk about individual charges, I'm going to say, and if there's some code that I'm not reading correctly, please tell me, because I'm looking at the booking report, which is the only thing I was able to get off of Odyssey, which is our online docketing system, to actually set out the charges other than the arrest warrants. So I'm going to...
So, Your Honor...
Okay.
I'm sorry, I didn't mean to interrupt. What I would tell the court is you are correct that unlike when there's an EW for electronic warrant, my understanding they used on each of the 11 separate warrants.
Okay. Okay. All right. Then that kind of solves that mystery. But as we begin to talk about each individual one, I will talk about each individual one as a charge, and then define exactly which charge I'm talking about. That's the only way I know how to do it. So at this point, let me say the following things. I want to address Ms. Miller, and I don't know if you're still on, Ms. Miller. I see that the victim advocate is still on. Ms. Miller, thank you very much. I can't imagine how difficult that must have been for you to address These things that, and this is exactly what I have a very limited issue. That issue has nothing to do, I'm going to temper that a little. This defendant is guilty of these charges. There is a specific set of law with regard to granting bonds in a case and specific things that the court is to look at. And I'm sure you understand, and I hope you understand that in our state and in our country, you're presumed innocent until you are proven guilty by a jury or otherwise. So I'm looking at this case at a very early part in it. And I would like to make the following comments from what I have seen, and this is all based on Ayala and the court cases coming out of Ayala. I want to lift up a couple of them to you, which I do want to mention. One is Howard versus the state, which is 197 Georgia Appeals 693. That's a 1990 Court of Appeals case, and it predates Ayala, but I don't believe that its line of reasoning was particularly overruled by Ayala. And then the same line of reasoning appears in 2008 in Hernandez versus the state, which is 294 Georgia Appeals 289 2008. And I mentioned these cases, and I found these cases specifically because they do stand for the proposition that that in addition to the Ayala factors, the court can also look at the seriousness of the charges in weighing the bond decision. And so I think that's important to take into account here. That's one thing. The other point of law that I'm sure everyone understands and knows about is sort of the black letter law that the trial court's foremost consideration when fixing the amount of bails should be the probability that the defendant, if freed, will appear at trial. And with regard to his being a flight risk, the flip side of that being his ties to the community, the court finds that those ties to the community have been demonstrated to the court's satisfaction with regard to being not a flight risk. I do want to note that there was a period of time, specifically from June 13th until he turned himself in, when he certainly understood what the situation was. He was given time, which I'm not criticizing, but he was given time to turn himself in, and I do think that it is reasonable to assume that a good time to have thought about fleeing would have been those early moments. I think given his employment history, and I will comment on this, and that is that the state criticized the defense presentation to the extent that there weren't specific, he lived at this address, went to this high school. I don't know. I have looked through the letters, and many of them are from fellow officers, but there's one from a parent of a friend of his growing up. There's one from a family friend of 18 years. I wonder whether some of that lack of detail had to do with safety. I do find that there's sufficient convincing factors in front of me that he does have sufficient ties to the community and he is not a flight risk. I do not believe that he is a danger to the community in the sense that Ayala sets that forth. I do not think that he is a danger of posing any significant risk of committing an additional felony pending trial. I do not believe that he poses a significant risk of intimidating witnesses, but I will talk about that. And I am therefore going to grant a bond. Now, I first want to go over the conditions, because the conditions are going to be very specific and they are going to be tailored to this situation. Number one, he will have an ankle monitor. Mr. Rolfe is going to have an ankle monitor at his expense. He will be fitted for that prior to his release. He will be subject to being monitored at all times. He will have the curfew. I think the curfew is reasonable, that's suggested by the state, from 6 p.m. to 6 a.m. And the exceptions that the court would approve would be work, legal, or medical. I think that we have all learned to live in terms of worship and other issues. I think we've learned to live remotely, and that can be accomplished that way. I am going to ask him to, if he has a passport, to surrender his passport. He will not be allowed to possess, own, carry any firearms. That would include rifles, as mentioned by the state. I kind of join Mr. Pines. I'm not 100% sure what knives mean, but if the use of a knife is an offensive weapon, he's not going to be doing that. But he will not possess, own, or transport or carry any firearms, weapons, guns, or rifles. Okay. He will not have any contact with other. I think the way that it was put was certainly no communication with the family members. There are, I would like to remind everybody, there are 4 victims, alleged victims in this case, correct? So there's Mr. Brooks, and then there are the 3 people who were in the SUV because they have the aggravated assault charges, correct?
That's correct.
Okay.
That's correct.
Thank you, Ms. Griffin. So that's all, that is the Brooks family and the 3 other witnesses. So he will not have any contact of any kind with any witnesses or victims, alleged victims in the case. And I think that we all understand if we need to put it in specifically, but that does not prevent his legal team from investigating the case. But he is not to have any contact of any kind. Let me see where I am here. He will not have any contact with other police officers. I think that's entirely reasonable. Certainly, if a situation arises which is an emergency, I think that we can all understand the rule of reason, but he will not have any contact with any other officers. I am not doing anything with the passcode to his phone. That is for another hearing. I will say, and anyone can correct me, and please correct me on the record if I'm wrong, but I believe that there is an obligation not to destroy, alter, or spoil in any way any evidence. Is that correct?
That's correct, Your Honor, and we, of course, will not spoil evidence.
Ms. Griffin, you agree with that? Because he's not. I agree that he is not going to do anything to that cell phone. So if we need to put that in there.
That is the requirement, that they not destroy or spoil any evidence. They have the search warrant. We have, even if they can destroy the evidence remotely, the warrant has been served for the contents of that phone.
Okay. Okay. So I think we're saying the same things, that we are now under the obligation on both sides that no evidence be tampered with in any way, correct?
That is correct.
Can I get everybody saying correct?
We agree, Your Honor. We will not do anything with the cell phone. It would be unethical to do that. The state has possession of the cell phone, and we will not attempt to wipe the cell phone. That would be illegal and unethical on our part.
Okay. Now, I think I've gone over all of the conditions. And now, we are going to need to talk in some fashion about where he will reside. But obviously, I do not want to go into any specifics at this point. So you have to tell me how we do that. because that is going to be part of the monitoring and so forth. But I want to talk about the procedure, but I do not want to talk about the location at this point. Okay, does everybody understand that? Can I get some head
Yes, Your
nodding?
Honor.
Okay. Then now I would like to go over amounts. This is going to be $500,000. I'm going to go over the individual amounts with you and how I got to that amount. But the court and that's why I specifically went through the case law that I cited to you, because this court does not feel this amount is excessive. So let's go through it, and as I said, I'm going to refer to the charge as it relates to the factual basis of the arrest warrant. Felony murder, $250,000. That will be a straight bond. Violation of oath by a public officer, I'm going to tie this one to didn't advise that he was under arrest. The bond for that amount will be $20,000 straight bond. Criminal damage to property in the first degree, I believe that was Mr. Evans' SUV. And this is a felony, correct? The first degree?
Yes, Your Honor.
The bond on that amount is $10,000 straight bond. Aggravated assault with a deadly weapon, that is for shooting Mr. Brooks. That will be $35,000. Aggravated assault with a deadly weapon, that is shooting at Melvin Evans. That will be $35,000. Shooting at Michael Perkins. So that's aggravated assault with a deadly weapon, and the factual basis for that one, I believe, is shooting at Michael Perkins. That will be $35,000. Failing, and now this is another violation of oath. I'm going to say this violation of oath is failing to render medical aid. That is $20,000. Aggravated assault with a deadly weapon, and this one would be shooting Danielle Killians, and that's going to be $35,000. Violation of oath by a public officer for shooting at or shooting Mr. Brooks, that is $20,000. Aggravated assault, kicking Mr. Brooks with his shoe, that is $20,000. Violation of oath by a public officer, and that was shooting a taser at Mr. Brooks, that is $20,000. Somebody check my math. I think that all adds up to $500,000. I am going to provide that that is payable through the sheriff's 10% program. Is there anything further?
Yes, Your Honor.
I should also add that under the Superior Court policy, until this matter is indicted and assigned to another Superior Court judge, it might be me, but I do retain I retain the case for purposes of bond only, any modifications or potential violations. Mr. Pines, were you going to say something?
Yes, Your Honor. I have a couple things. One, the no contact with other police officers, do you mean any other police officer in the country, or do you mean any other Atlanta police officer?
I mean any other Atlanta police officer. I think I think the point Mr. Rucker brought up was that once an investigation is, and I'm not really sure, I guess I could let Mr. Rucker speak for himself, but the point that I took was he just does not need to be discussing this case or having conversations with other police officers, and I'll say Atlanta police officers. What else?
The other issue, Your Honor, is who, I mean, I will take one of us, when I say one of us, one of his defense lawyers will take possession of the passport.
You can,
and
he can surrender it
court?
to his attorney in trust during the pendency of this case.
Okay, I will, once, whoever has possession of the passport, we will notify the district attorney's office about that, okay?
Okay.
You talked about the ankle monitor and an address. What we would like to do is present the address to the ankle monitoring company once it's placed on, and then we will also provide that address to the district attorney's office as long as that is kept in confidence.
I don't see Mr. Rucker, but Ms. Griffin, I see that you're on here. I'm going to.
Yeah, Mr. Rucker lost his Wi-Fi connection. I think it's storming in his neighborhood, but that is fine.
Okay, Ms. Griffin, I'm going to put in there that it shall be under, it shall be confidential.
That is fine.
Okay. What else?
Okay, we'll do that. And then the last part, Your Honor, is assuming that the ankle monitor gets fitted and the Fulton County Sheriff is satisfied that the bond has been posted, may he be released directly from where he's being held right now, which is not the Fulton County Jail. Obviously, the Fulton County Sheriff would have to communicate with, everybody knows he's in Gwinnett County, would have to communicate with the Gwinnett County Sheriff. The Gwinnett County Sheriff would verify the ankle monitor is on, the Fulton County Sheriff would verify that the bond has been posted, and then that way he can be released directly from Gwinnett County.
I have no problem with
So
that.
we would ask.
Ms. Griffin, do you have any problem with that?
I am not sure that the court could outline that. That is strictly up to the Sheriff's Department how they would effectuate his release from the jail.
I think, Your Honor, if you just put in there that assuming both sheriffs are, satisfied that the bond has been posted and the ankle monitor has been placed, that the Gwinnett County Sheriff, the Fulton County Sheriff may authorize, because it's may, not shall, but may authorize the Gwinnett County Sheriff to release him directly from custody.
I have no problem with that, if that's within the court's purview, but I think it's within the sheriff's office purview. But however, it got handled some way on the intake, and so I would assume that it would be handled similarly on the release.
Okay. I think if the court just puts that in the order, then it'll be acceptable to everybody.
I will put it in there. I don't know that it will happen because even if somebody.
Understood.
Okay.
We'll put it in. I will put it in.
I understand.
Anything else?
I believe that's all I have, Your Honor. Thank you so much for your time. We really appreciate it.
Okay. I appreciate
Nothing
everyone's.
from the state, Your Honor.
I appreciate everyone's. I appreciate everyone's appearance today. Thank you very much. We're concluded. Thank you, ladies and gentlemen.